there were many acts like before RERA, there was MOFA. MOFA is still there. It is not yet repealed. But why there was a need to bring a particular act like RERA? Like, have you heard about the Harshad Mehta scam, 1992? Then Ketan Parekh scam. Till that time, the SEBI was not there because the government realized that they have to regulate this stock market because many scams are happening and people are losing money. So after SEBI, I'm not saying that the scams are not happening, but it is not happening at the larger scale, which used to happen during the Harshad Mehta time and Ketan Parekh time. Now, similarly, in housing sector, especially, the home buyers were taken for a ride, by the builders, and they were like acting like a mafia. The 400 square feet flat, they used to sell it as a super build-up to 700 to 800 square feet, 100% they used to add. So there was no carpet area concept was there. So that was one gray area which RERA took care of it. And I have myself filed many complaints where the possession date in the agreement was not specified. And I got the first order in such agreement where the possession date was not specified because the RERA was the opinion that they cannot rewrite the contract again. So you have accepted that there should be no possession date. So then I quoted NCDRC judgment and then Supreme Court judgment, which says if the builder has taken more than 20% of the amount, then 3 years' time is a reasonable time to construct a building. And the first order in RERA, where the possession date was not specified, was obtained by me. So similarly, now I am not telling that RERA has answered or addressed all the questions. The main essence of the RERA is still, not put into the action. I will show you that, how many orders we have obtained, but they are still lying there without execution. So it is like a piece of paper. Similarly, after obtaining the order, the RERA has filed complaint against 137 buyers of the same project, which the RERA doesn't have the provision, but still that complaint was entertained. So why we should go to RERA and why we should go to the consumer forum? First, we will see the key factors, the key features of the RERA, and then I will discuss the orders obtained by me in the RERA and how the builder had filed a complaint. And now what is the difference between RERA and the consumer court? So let's go ahead. I'm sharing the PPT. Now, Real Estate Regulation and Development Act 2016, but which came into force in Maharashtra in May 2017. It was having a five-fold object: to establish the Real Estate Regulatory Authority, promotion of real estate sector, to ensure sale of real estate project in an efficient and transparent manner, to protect the interests of the home buyers in the real estate sector, to establish an adjudicating mechanism for speedy dispute. Now, what was happening earlier days, that if you file a suit against the builder, it will not come to the final conclusion till decades. It will take 10 years, it will take 15 years, and cost of the litigation was very high. Now, normally, if I speak about a flat in Andheri to Kolaba or from Kurla to Kolaba, the flats are around 1.5 crores to 2 crore rupees or 1 crore rupees. The stamp, the court fee itself was coming around 3 lakh rupees. And the advocate will also charge a 3 lakh rupees fees because it's going to be a long this thing. And now suppose if the builder engages a senior counsel, right, then your advocate will also suggest you that to counter that senior counsel, will also have to engage an advocate up to his level. So that again used to, cost 2 lakh, 3 lakh, 4 lakh rupees. So total cost of that litigation of that flat was coming to around 10 lakh rupees. Now the RERA came into picture. It says that you have to pay only 5,000 rupees as a court fee, no matter whether the cost of the flat is 10 lakh or 10 crore rupees. So it brought the litigation cost also. And in initial stage, the first order against the Ekta builder was passed within 15 days. So it was that quick. And, I used to promote to all the home buyers that you don't go anywhere. You don't go to the consumer court because consumer court is taking 2 to 3 years. You go to the RERA because there is a speedy redressal of the complaint. Then came to 2 months, then 6 months, 1 year. Now, even after 1.5 years, we are not getting even the first date of hearing. So there is a backlog and number of complaints is increasing, and there is some problem with the system. So the essence of the RERA for which it was brought into effect is not getting the same result as desired. Now, important aspects under RERA, provision pertaining to the following: promoters, real estate agents, even the real estate agents who are selling under construction properties, whether it is a flat or whether it is a plot, he has to be registered. Then the allottees, the consumer, concerned authorities, and miscellaneous. Dear Mr. Promoter, say hi to the new key to the treasure box that is called registration. Now, in this, the builder has to register its project if he wants to sell it or if he wants to even advertise it. So if there is no registration, he's not supposed to sell or book the flat. So now the treasure box is the promoter has to get registered into the RERA online. So if the builders are there, we can take a different session, a separate session for the builders that how to register themselves with the RERA. Now we are talking at the aspect of the home buyers. Section 3, no promoter shall advertise, market, book, sell, or offer to sell to invite person to purchase in any manner, any plot, apartment, or building in any real estate project, in any planning area, without registering the real estate project with the RERA. The section 59, very important, but this is hardly been implemented. The penalty will be approximately, up to 10% of the estimate cost of the project. Now, say, suppose the cost of the project is 200 crores. The penalty to the builder, we can have a penalty up to 20 crore rupees. So that is the beauty, but it is not been implemented. Second, if the above penalty is not paid and violations continues, promoter shall be punishable with imprisonment, which may extend to 3 years, or fine, which may extend to further 10% of the estimated cost of project, or both. But I have never seen any of the presiding officer of the RERA has passed this type of order under this section. So the RERA has to act like a consumer forum where the presiding officer has both the jurisdiction, civil and the criminal. If the builder doesn't comply the order, he can be sent immediately to the jail. The validity of registration till the date of completion as stated by the promoter. Now, suppose if the promoter states that my project will be completed by 2024, his registration will get over by 2024. Extension of registration. Registration may be extended due to circumstances beyond control of the promoter, force majeure, namely flood, drought, fire, cyclone, earthquake, or the natural calamities like what we have seen in the past about the COVID. So 1 year extension was given to the builder because of the COVID. Exemptions from the registration. This is very important. Area of land proposed to be developed does not exceed more than 500 square meters. So there is no registration if it is under 500 square meters. Number of apartments proposed to be developed does not exceed 8, inclusive of all phases. Now you cannot say that first I will construct 8 units and in the second phase I will construct 8 units. No, if it is more than 8 units, then it needs a registration. If it is less than 8 units, the RERA registration is not required. But now we had a very, challenging situation in JVPD scheme. The builder was constructing exactly 7 flats. So there was no requirement of the registration. Now, when you don't register with the RERA, the even bank does not give you the loan to the prospective home buyer. So what has to be done? So we somehow managed the top 2 floors and we created one flat into 2 flats so that the number of units goes from 7 to 9. And for the same flat, there were 2 separate agreements. And when he registered with the RERA, his flat started selling. It was in a prime location. So this is where you have to understand. And ongoing projects to be registered to 1st August 2017. So that is over now. But there are still, get complaints or I get calls from my colleagues that the project was started in 2015 or 2013. It is still not yet registered. You have a good chance. You have to file a complaint in the RERA that the project is an ongoing project and it is still not registered. Project for the 3 years not involving that like marketing, advertising, selling or allotment. That is, if there is a repair or renovation or reconstruction of the same building with the same units, no sellable component, or redevelopment of the building without any sale component, they don't involve, they are not supposed to register with the RERA. So these 3 R's you have to keep it in mind. Mr. Promoter, let's spit in all out. Disclosures in application, section 4, subsection 2, detail of the project constructed in the last 5 years. So you will know the background of the builder, that what he has constructed. You can visit that site, whether there are any litigation, what is the quality of the work undertaken by the developer. And then you have an information and you are taking an informed decision whether I should buy, I should go for this project or I should reject. Authenticated copies of approvals and commencement certificates. Now he has to upload. Now normally what used to happen before RERA, the draft agreement was never shared. This is the draft agreement is shared on the website of the builder. You have to download it, go to an advocate, your family advocate, or engage an advocate and have a verification. Let him scrutinize whether the agreement is as per the RERA. It is a balance agreement or it is a one-sided agreement. So we can take an objection. Then you will see the sanction plans and layouts and the specification. Now, what was happening prior to RERA is you pay the money 90%, 75%, 80%, or even 100%, and you have to chase the bidder that please register my agreement, register my agreement. Then he will one day call you that tomorrow morning, 10 a.m., you come to the sub-registrar office. You have not seen what is there in the agreement. You just sign on the dotted line because you have spent around 2 crores or 3 crore rupees. You have already parted with the builder and you don't have the time and energy to fight the builder. So you sign it, whether the possession date is specified or not, whether what are the amenities are there or not. You don't know. You just sign it. And then after 2-3 months, again, follow up with the builder, you will get the registered agreement. Now things have changed. Whatever he wants to give you, whatever the amenities he wants to give you, whatever the possession date, everything has to be shared in the draft agreement. And if you have any issues, you can discuss it or you can complain to the RERA. Number and areas of garage for sale. Where promoter is not the owner, agreement entered into between the promoter and the such landowners. They take for the JV. JV is, they enter into a joint venture partnership. The landowner is given certain flats to accommodate the cost of the land. He is given 10 flats, but even that landowner becomes the co-promoter. And if anything goes wrong, he is also held liable. FSI and TDR and other entitlements which are proposed to be utilized. Aggregate area in square meters of the recreation open space. So now what used to happen, that the builder will construct 1 tower or 2 towers, then he has an additional area which initially used to say that this is the recreation area or this is a garden plot. Then after completing the 2 towers, then again he will do some management, or in Mumbai's language, we say that he will do some jol and start 1 more tower in the open space. So after the RERA, he cannot do this. The promoter has to give everything legally, that the legal title, there are no encumbrances, date of completion, which we never used to have in the previous agreement. So Then 70% of the amount collected from the allotee is to be deposited in the schedule bank to cover the cost of construction. Suppose now if I have booked a flat and I pay my first installment of say rupees 1 lakh. So 70,000 has to go into the construction of that project or that building. 30% he can utilize for his administration, for his staff, or some profit. So everything he has to keep a record, and every quarterly the chartered accountant and the structural engineer will submit the report, which will be uploaded on the RERA website, that this amount has been collected and this much amount is spent on the construction, and 30% is only withdrawn by the builder. And if he does not do that, Section 60 comes into force, penalty up to 5% of the estimate cost of project. This is very important to note. Mr. Promoter, watch your footsteps. Section 7, revocation of the registration. Authority may revoke a registration on being satisfied that the promoter is defaulted in doing anything required under the Act, rules, and regulation. The promoter violated terms and conditions of the approval. The promoter is involved in unfair or fraudulent practice or irregular consequences, no access to its website. Name of the promoter to appear on the list of defaulter on the website, and it is circulated throughout India. So if suppose the builder is having a project in Delhi, that project will also be affected, because now everyone will come to know that this builder is blacklisted. So we have to take care whether we should enter into transaction or part our money with such blacklisted builder. Name of promoter to appear on the list of defaulters on the website. Deregistration communicated to the authority in other states. This is what I told you just now. Freezing of bank account with schedule bank. What is the status of the project post revocation of the registration? Now we come to the Section 8. What happens if the registration is revoked? What is the remedy available to the home buyer? Functions and duties of the promoter. Section 11. Website during booking, issue of all allotment letter, and other, like suppose I have booked a flat of 1 crore rupees. The consideration value is 1 crore rupees. And I have given what you call token, and then I'm giving him the first installment. The moment it crosses more than 10%, I have paid 10 lakh rupees, but even if I'm supposed to pay him 10,000 or 50,000, about 10 lakh rupees, the builder cannot ask money until and unless that document is registered. So this is very important. Initially in MOFA, it was 20%. After paying 20%, it was the duty of the builder to get the registration of that document, but it never happened. So that's why the RERA came into force. Create a web page, enter details as stated in Section 4, subsection 2, and quarterly updates on the project, disclose advertisement and prospectus. So every quarterly, he has to update that how many flats he has sold, what is the state of construction, how many floors he has constructed. Every detail will be there on the click of the mouse. You just have to open the website and you will get all the details of the builder and about the project. During booking and issue of allotment letter, disclose sanction plans, layout plans approved by the competent authority. Now, this is the right of the allottee, that he should see the sanction plan. Now, what happens, even after RERA coming into picture, they show you while booking a sale plan. They will not show you the sanction plan, which has the stamp of the authority, says this is approved. They will only give you the sale plan. So your job is to see that you see the sanction plan and compare it with the sale plan. If you can't do it, you ask your advocate or an architect to compare whether the same sale plan is the same as per the sanction plan. Disclose stage-wise schedule of completion of the project, including the provisions of civic infrastructure like water, sanitation, electricity. This is the right of allottee to have all the things. Fulfill obligations and functions as stated in the Act, rules, regulations, and agreement for sale. Obtain completion certificate and occupation certificate. Now, this is very important, you know. People feel that if he has obtained occupation certificate, then that is the end. No. Occupation certificate is a certificate where it certifies, means there will be an NOC from the CFO, that is Chief Fire Officer. that all the compliances of the fire have been met. In case of emergency, they have enough firefighting system installed. But after getting the occupation certificate, he has to complete the layout, the compound wall, and whatever the work is there as the common amenities. And after that, he will get a building completion certificate. So that is also your right. You should not stick to only occupation certificate. Obtain lease certificate where the real estate project is developed on a leasehold land. This is very important. Form a legal entity like association or society or cooperative society within 3 months from the date on which the 51% of the total number of allottees in the building have booked their apartments. This serial number 4 is very important. You should understand where it clearly says form a legal entity like association, society, or cooperative society within 3 months from the date on which 51% of the total number of allottees in the building have booked their apartments. It has never mentioned that there is an agreement is executed, right? The moment you book the apartment, whatever the amount you pay, 1 lakh, 2 lakh, 5 lakh rupees, you have an allotment letter. The moment he books the 51% of the units, say there are 100 units in that project, and he books 51% of the units, say 51 number units are sold, no matter whether the agreements are registered or not. He is supposed to form an association of allottee or society or a cooperative society. But this never happens, even because we are very lazy and we are not aware about our rights. So with the PLEA and with my NGO, we want to empower the citizen that you should know your right and you should ask for the right. So the moment 51% of the units are booked, you should write to the bidder that when are you forming the society? If you are in Mumbai, ask him to form a cooperative society. Or if it's not possible, then form an association of allottees. So in case in future, if you want to go in for a litigation, the association is going to fight for the members, which will reduce the cost of the litigation. Pay all outgoings collected from the allottees till physical possession is transferred. Not to mortgage or create any charge on property after execution of agreement for sale. Cancel allotment only on terms of agreement for sale. So this is also very important. Allottees, smile please. How many of you are here home buyers? There should be a smile on your face when you see this. These are the most important sections like 12, 13, 14, 15, and 18. If you know these sections very well, you know the whole RERA Act and you can become practicing advocate or a practitioner in RERA if you're a chartered accountant. So now what does the section 12 of the RERA says? Loss sustained due to the incorrect or false statement in advertisement or prospectus. There are many cases, I don't want to name them. There are very good builders also, reputed builder also. In the brochure, they had given that there will be a swimming pool, there will be a clubhouse, and there will be one Jain Mandir while selling that. And we take the prospect and we feel that the builder will construct it and give it to us. Now, what happened in this particular case? This case is still going on because 3-4 home buyers got a positive judgment from the RERA, but still that they have been challenged in the RERA appellate. Now, what trickily the builder did is they never mentioned the name of the project, the schedule, the description of the property. They just gave you the brochure and you are happy. Even I did not realize in the first, then when I was going through it, I saw that the builder has not mentioned anything that he is going to construct it. So it was a brochure, but then there was something where we can connect it. Then we were asked that, how did you get this brochure? You have printed yourself. So we got some connection because the layout plan, sanction layout plan were the same. And then we went to the BMC. We took an inspection under RTI. So in the RTI, it was, in the plan, it was proposed that there will be a swimming pool here and a clubhouse, but it was never sanctioned. It was just proposed. So then we nailed the builder. So now section 13, what says? No agreement for sale no advance deposit. Like they cannot collect more than 10%. The moment they want to collect more than 10% from the consideration value of your flat or unit or the plot, they have to execute an agreement. Now, when you are going for an executing of that agreement, what you have to see is first, the area what is mentioned in the agreement. Second is the date of possession. And third is the amenities like clubhouse, swimming pool. If it is not mentioned there, do not sign it. And you can complain to the RERA that I have given the allotment letter, and while booking and giving an allotment letter, the builder has so and so things now, which is not reflecting in the agreement. So you stop there and you have to see that it is as per the sanction plan. Now, section 14, adherence to the sanction plan. Promoters squad cannot act without consumers not. Allottees specify and promoters rectify. Now, what does this mean? Now, suppose I have booked a flat, say he has given me 750 square feet carpet area as per RERA, 2 BHK. Then while constructing, he has changed the plan. He has made 1 bedroom small, 1 bedroom bigger, and the area is also changing now 725 square feet or 800. So I can always take an objection because he cannot change the layout without my consent, because I have made the payment, seeing the layout, what I was shown at the time of booking, and after that the builder doesn't have the right to change the layout. So this is very important, a very powerful tool which is given to the home buyers. It is only you have to use it. Section 15, obligation of promoter in case of transfer of a real estate project to a third party. Now, what was happening initially, the builder used to start the construction. Then after few years, either they have, swindled the money or misappropriate the money, and they were not able to construct the balance portion of that project or the building. Then they used to, enter into an agreement with a third party. So now in that also, without your consent, he cannot enter into a third-party contract. Section 16, insurance of real estate project. So whatever the cost of the project is there, he has to insure that. Then section 17 is transfer of title, conveyance and common area, which he has to do it. Means all the common area belongs to the society, like terrace, then open car parking, which all belongs to the terrace. Now, section 18, the life, the heart of the RERA. If the promise is broken, let money apologize. This is the right of allottee. Interest plus compensation or interest. Now, initial stage, if you see my my blog, Wikipedia, we had obtained an order where the compensation was up to rupees 5 lakhs. Then it was subsequently, after some time, it was reduced to 2 lakh, 1,50,000. Now, in the name of compensation, RERA is only passing the order of 20,000 rupees plus interest. Interest is very simply calculated. The State Bank of India's lending rate plus 2%. Suppose the State Bank of India's lending rate is 7%, then 7 plus 2, it becomes 9%. So this is the section 18. Now in section 18, there are two provisions. One is, I want to continue in the project. I was promised that I will get the delivery by 2019. December 2019. But today is what? 2023. But the location is good and I don't want to miss that location. So I want to continue in the project. So what I will do is I'll file a complaint against the builder in RERA or in consumer court. Now we'll see in the end what is the pros and cons of RERA and pros and cons of consumer court. Then I can write in that complaint that I want the interest for the delayed period of possession and plus compensation. You write whatever the figure you want to write, but for the compensation, you will get 20%, 20,000. For the interest, minimum 9%, I am assuring you that RERA will grant you 9%. So from 2019, 20, 21, 22, and 23, it comes to around 4 years. So 1 year we deduct because of the COVID. So 3 years. Now, suppose if you have paid 1 crore rupees to the builder, so every year, you will get 9 lakh rupees as an accumulated interest, simple interest, no compound interest. So of 3 years, if I calculate, it comes to 27 lakh rupees, a big amount. So either it can be adjusted to the amount to be paid to the builder at the time of possession, or he has to pay you at the, whatever the difference is there, he has to pay you at the time of the possession. So section 18 is the heart of RERA. No matter what happens, my request will be to all the state government and central government that don't change or dilute the section 18 of the RERA. Now, section 61, contravention of any provision except section 3 and section 4, the rules or regulation made is the penalty up to 5% of the estimate cost of project. So suppose if there is a contravention of section 3 and section 4, the cost of project is say 200 rupees and there is a penalty which can be up to 5%. And suppose the adjudicating officer or the presiding officer of the RERA wants to penalize the builder, he can penalize the builder up to 10 crore rupees, a very big amount. Agent, let's know who you are. Section 9. Registration. No real estate agent shall facilitate sale or purchase of any plot, apartment or building in real estate project registered under section 3 without obtaining the registration. So the agent also have to apply for the registration. They will get a registration for that particular project. It is not that one registration he can, sell throughout Mumbai or throughout Maharashtra or throughout India. For every project, he has to get the registration. And he has to keep the documents, accompanying application, right? Recent photograph, income tax return for the last 3 financial years, proof of address of principal place of business, telephone numbers, etc. Details of all civil and criminal cases pending against him. Validity of registration. Registration to be valid for a period of 5 years. Registration number to be mentioned in every sale facilitated by the agent. Bar on registration. No fresh application shall be accepted for a period of 6 months from the date of revocation or suspension of the registration. So this is good that, even the agents used to take home buyers for a ride. So this will have a little cap on them. Functions of real estate agents. No, not facilitate the sale or purchase of any plot, apartment or building in an under registered real estate project. So he cannot, if the project is not registered, he cannot promote that project and he can sell it. Again, this is a crime. He can be punished for that. Maintain and preserve prescribed book of account and documents as prescribed. Facilitate the possession of all the information. Section 62, penalty up to 5% of the cost of the plot or apartment or building for which the sale or purchase has been facilitated. So suppose if he has done anything wrong and the value of that apartment is only 2 crore rupees. So if the 5% penalty is levied on him, so it comes to 10 lakh rupees, a big amount for an estate agent. The other side of the coin, allottees, you are also not exempted. Means now the duties of allottees under section 19 is that payment to be made as per the terms agreed in the agreement for sale. You cannot say now the RERA has come, I'll pay whenever I want. No, whatever you have agreed in the terms of the agreement, you have to pay. Delay in payment of above charges will attract payment of interest. Now, initially what used to happen, this is a very interesting thing and you should make a note of this. The builder used to write that if the home buyer defaults, I am going to charge 24% interest per annum, 2% per month. But suppose if he defaults, then he would say that you can charge me only 9% of the interest. Now in RERA, whether the builder defaults or the home buyer defaults, the scale is the same. State Bank of India lending rate plus 2%. So it is very clear he cannot have a one-sided agreement that if the home buyer defaults, I'll charge you 24%. And if I default, I'll give you 9%. So that is not going to happen. Delay in payment of above charges will attract payment of interest. Take physical possession within 2 months of the issuance of the occupation certificate. Now, the moment the builder obtains an occupation certificate, say today it is January 2023, 21st, and he sends you a letter with a copy of the occupation certificate, that you have to take the possession within 60 days or 2 months. So February, March. So March, 20th March 2023, you have to take possession or before that. Participates towards the formation of legal entity, that is society, association of allottees or cooperative society. So you have to participate. You cannot say that I will not participate in any of these things. Authorities under RERA, Real Estate Regulatory Authority composition, 1 chairperson and minimum 2 whole-time members. Filing of complaints. Complaint may be filed by the aggrieved person under Section 31 of the Act for the violation of the Act, rules or regulations. Manner of implementation of orders. If the same manner as if it were a decree order made by the principal civil court or original jurisdiction in a suit, or send the order to the principal civil court for execution. But I'm very sorry, I have obtained many orders, but this is not happening. But there is a good news that I'm going to share in the end, that RERA has appointed a dedicated officer to see that whatever the orders have been passed by the RERA authority has been complied or not. If not, then that officer is going to take action on that builder. So I will share that also, that is on my blog. But let's see the things happening in this. Address of hearing of complaints, where Bandra East, now they have in Churchgate also, Bandra Kulla complex also. And nowadays, one good thing is happening is all the RERA complaints, whether it is RERA, appellate tribunal or RERA, everything is happening online. So even the home buyers, they don't have to participate while physically, but they can, through their mobile also, they can see that what their advocate is arguing about and how he is presenting his case. So this is a very good thing that all the RERA hearings and appellate tribunal hearings are happening online. Now, period of disposal, here where I'm going to file a PIL, which says that within 60 days from the date of receipt of application, the moment my application is uploaded, I have made a 5,000 payment and all my documents are uploaded, like allotment letter or agreement and the receipts and everything. So within 60 days, I should get the judgment. So initially stage, it was happening. Now it is not happening. Now the first hearing date of RERA itself is coming after 1.5 years. So this is where we like-minded people have to file for justice of the aggrieved home buyers or for the empower the citizens of India. Stages of inquiry after filing the complaint. So first hearing will be for the appearance. Second date will be the recording of the plea of the respondent. If pleads guilty, then order. If not plead guilty, then the explanation reply to be filed by the respondent. Then the third stage is leading the evidence, oral or documentary. Fourth is final arguments. And 5 is the final order. So now suppose each stage takes, say, 30 days, one month. So within 5 to 6 months, the RERA has to pass the order. But now the first hearing itself is coming after 1.5 years. So this is where, I want to have like-minded advocates and people so that we can file an PIL and we can see that, the High Court or the Supreme Court passes an order that you have to adhere to this, that you have to finish the complaint or dispose of the complaint within 60 days or maybe 90 days, not more than that. Consequence of breach of order. Promoter, Section 63, penalty up to 5% of the estimate cost of project. Agent, penalty up to 5% of the estimate cost of the building plot or apartment for which sale or purchase was facilitated. Allottee, Section 67, penalty up to 5% of the estimate cost of building plot or apartment if he also is not adhering to the order of the RERA. So RERA has done a balancing act. Now we come to the appellate tribunal. The Real Estate Appellate Tribunal. Composition, 1 chairperson and minimum 2 whole-time members, one being a judicial member and the other technical and administrative member. Jurisdiction, try appeals from the order of the Real Estate Regulatory Authority. Now this is very important and something interesting which I want to share you. Initially, the builder used to go to the appellate tribunal. So he has to pay minimum 30% or 50% or 100%. It depends upon the presiding officer. Now, when Indra Jain was there, she used to say that, no, you deposit 100%. Now, suppose the refund order is for the 2 crore, the principal amount, and 30 lakhs for the interest. So if the builder wants to go for the appeal of that order, he has to deposit 2 crores 30 lakhs in the appellate tribunal. Then only his appeal will be heard. Now, we call India as a jugadu. What they do is, builder, if he goes to the appellate tribunal, he will have to pay the 30% to 100% of the amount which has been there in the order. He smartly files a review application for which he doesn't have to pay even the 5,000 rupees. And he comes out with, silly excuses and does the time pass for 6 months to 12 months or maybe 18 months in the RERA authority itself for the review application. So in that case, the home buyer has one remedy where he can go for the execution of the order. He can file the execution of the order. But the execution of the order, what happens? The practical difficulty is the RERA authority will send it to the collector. Collector will send it to the tehsildar for the attachment of the bank account and the property of the builder. But builder knows very well that now the order is going to come. So he removes all the money from the bank and that property is also transferred to someone he knows from his family members or from his friend. So, and that order is not executed. So now they have appointed a dedicated officer to see that the orders are complied. So I will share that also with you in the end. Period of limitation. Within 60 days from the date on which the copy of order is received. Now, the moment you get the copy of the order, the certified copy of the order, within 60 days, you can file appeal. It is not that builder always goes and file appeal. It is the home buyer also has to file an appeal, because what happens, sometimes the RERA authority doesn't understand and they go by the words of the respondent advocate and a wrong order has been passed. So that impugned order has to be challenged within 60 days. Manner of implementation of orders. Order to be executed by the appellate tribunal as a decree of a civil court. Then suppose if you are not happy with the appellate tribunal order also. So what you can do is, you can appeal to the High Court within 60 days from the date of communication of the order of the appellate tribunal. Now here, why I prefer consumer court is, suppose my value is more than 2 crore rupees. And even I have to claim for a refund of the entire thing because I don't want to continue in the project because the project has been delayed for n number of years. So my remedy lies with the NCDRC. That is in Delhi. So what happens in NCDRC, say within 2 years you get the order. And if anyone wants to challenge that order, it has to go only to the Supreme Court. So all the time which has wasted here, like first you go to the RERA, then he goes to the review, then you file compliance of the order, then it goes to the appeal, then from appeal it goes to the High Court. So the time pass is done here more than 5 to 6 years or 7 years. So I would prefer either you go to the State Commission or NCDRC, because after State Commission, if he wants to challenge, he has to go to the NCDRC, and from NCDRC, the one step ahead is the Supreme Court. So the time consumed in overall in the consumer litigation is less than in the RERA. That is what my experience is. People may have a different experience, because initially I also had a good experience that orders were getting in the favor of the home buyers, but then the problem was that it was not implemented. Consequences of breach of order. Promoter, Section 64, imprisonment minimum 3 years or fine up to 10% of the estimated cost of project or both. But this has never happened in the last 5.5 years. And it is not going to happen, because in RERA, all the presiding officers, either they come as an commissioner of MCGM, or they have worked as an secretary of UDD department or Mantralaya. So they are already hand in glove with the builder. I'm saying it openly. So it is better to go through the consumer forum. The real estate agent, section 66, imprisonment maximum 1 year or fine up to 10% of the estimated cost of plot, apartment, building for which sale or purchase has been facilitated or both. Allottees, section 68, even you can be in imprisonment, but don't worry, nothing has happened of such sort till date in the RERA. Maximum 1 year or fine up to 10% of the estimated cost of building, plot, apartment or both. Parking space. With RERA, see that there is a clarity, no doubt about it, that the RERA has done very good in many aspects of the construction industry or housing industry. Open parking area. This has been clearly included in the definition of common areas, which need to be conveyed to the Association of Allottee after the occupation certificate is received. Hence, sale or allotment of open parking areas by the promoter is not permissible. This is a very clear-cut definition of open parking area as per RERA. Covered parking, as defined in the Act, is permitted to be sold. So builder can sell covered parking or a garage as defined in the Act is permitted to be sold. These are the judgments on RERA. The first judgment, which is the Fortune Infrastructure, now known as Econ Infrastructure and others versus Trevor Dimela and others. This was, the project in Bandra, very near to my building where I stay, and I was following this. In this case, the learned Supreme Court held that 3 years is a reasonable time period for construction. This is a very important judgment. This you will find it on my blog also, and it is available on the net also. Just Google it and you will get it. Based on this order, I was the first one to obtain an order where the date of possession was not specified in the agreement. So I quoted the same judgment, and this was the first order by the RERA where the possession date was not specified in the agreement. Then Pioneer Urban Land and Infrastructure Limited with this Govind Raghavan on April 2, 2019. In this case, the learned Supreme Court held that the buyer can be expected to wait for a reasonable period and not indefinitely. Also, proceedings under Bankruptcy Code 2016 IBC and RERA can sustain parallelly. So this is a very important this thing. If the matter is going on in the IBC, I have the right to file a complaint in RERA. So both can go parallelly. It doesn't mean that if it is in the IBC, the RERA doesn't have the jurisdiction. Then Manjit Singh Daliwal versus JBPD Properties Private Limited. In this case, the learned RERA appellate authority observed that the complaint filed on the basis of allotment letter is a valid, and the complaint of the allottees will not fall for want of agreement of sale. Because there are many smart advocates who said this is an allotment letter, there is no agreement, so there is no agreement. But in this case, it was mentioned that even that allotment letter is an agreement. So this has come into the favor of the home buyer. Then Nilkamal Realtors Suburban Private Limited versus the Union of India on 6 December 2017, writ petition number 2737 of 2017. In this case, the learned Bombay High Court held that the provisions of RERA are extant retroactive or quasi-retroactive, and the Parliament has power to legislate even such provisions and are not ultra vires to the Constitution. So there was a very big, this case was there, many senior advocates, senior counsel, all were involved, and a good judgment was delivered by the Supreme Court and the Bombay High Court. Techno Drive Engineers versus Indus Infra on 26 November 2019. In this case, the learned Mahara held that the only residential and commercial project come in ambit of RERA and not industrial project. So if there is an industrial project, it will not come into the ambit of RERA. So you have to go to the Consumer Court. Anita Castellana versus Godrej Landmark Developers Private Limited. In this case, Mahara Section 12 and 18 operate at two separate times of the transaction. Section 12, which relates to the veracity of the advertisement, which is prior to the signing of the agreement, and the post-execution of the agreement, Section 18 can be invoked. So this is also a very fantastic judgment. You should refer this. Mahara versus Piramal Realty Glider Buildcoin Realtors on 5th April 2018. In this case, Supreme Court held that the regular updates pertaining to the progress of the project should be provided by the builder to allottees. Ajay Nagpal versus Today Homes and Infrastructure Private Limited, April 7, 2019. In this judgment, RERA held that an aggrieved home buyer has now an option to initiate legal proceeding against the errant developer builder in either in RERA or consumer court, but it has to be seen whether these complaints are timely concluded or some relief is provided to the aggrieved home buyer. So now in 2019 judgment, it has come that either you can go in RERA or in consumer court. So there is no bar, but you cannot go to the high court because there is bar of jurisdiction is there. First, you have to approach RERA, then appellate tribunal, then only you can go to the high court. Then there are many judgments which I will send you the link. Now, this judgment, Brijesh Hirji versus Skyline Construction Company on 21st February 2019, very important, which I was talking about. In this case, RERA held that no date of possession in the agreement of sale is violation of Section 13 of RERA as well as Section 4 of MOFA. So this was extensively argued by me and Brijesh Hirji. You know, he's a celebrity, he's an actor. He has worked in the film like Golmaal Hai with Ajay Devgan. He was my client and I had argued extensively on this because there was no date of possession mentioned in the agreement. But after quoting the Supreme Court judgment, the order came into my client's favor. Okay, now RERA appoints special officer to follow up recoveries from errant builders. Nearly half of the warrants worth rupees 730 crores issued by the real estate regulator over the past 5 years for irregularities and recoveries remain unpaid. So when we start, keep on writing, our NGO keeps on writing on the chairman of the RERA, then we write to the chief minister that what is the use of bringing RERA when the orders are not implemented. So now they have appointed a special recovery officers. So I hope this officer does something and the essence of the RERA is retained. So retired additional collector Anant Dinkarao Dahipale has been appointed to take action on the warrants, follow up and manage the cases in regular coordination with the respective district collectors and officers. Now I'll share you one thing here, which I have not shared you or I have not shared in the earlier videos also. When your case is pending in RERA, or suppose it is a recovery order is issued to the collector and Tehsildar are not acting, what you can do is you can file a writ in the High Court. Now, in one of my case, after 6 months also, because the order was supposed to come into my favor or my client's favor, the RERA was hesitant to pass the order. So what we did is we filed a writ petition. We served the copy to the RERA and the hearing was on Thursday, Thursday. Morning, we went there. All the councils of the builder, of the Maharashtra state government, of the RERA officers, all were present. And they said to the judge that we have uploaded the order. So I, said that 9:30 p.m. Yesterday, I saw the order was not uploaded. They admitted that the order was uploaded at 11 p.m. in the night. So in such cases, even in RERA, you have to keep a provision or you have to explain it to your client that if some such delay happens, then we'll have to shell out some money to approach the High Court. Then the moment you go to the High Court, immediately things will start happening. So that is the beauty. Now I am coming to one more truth of the RERA. Can you see this is the final order? The present complaints are disposed of and the following order is passed. The complaints are entitled to interest for delay in possession as per the said allotments number 1 and 2, the rate of prescribed therein. The respondents are directed to execute agreements for sale as assured in the said allotment of numbers 1 and 2, forthwith following which the penalty of rupees 1,000 under the section 63 of the said act shall be levied on the respondents on per day basis till the default continues. The aforesaid penalty shall be paid by the respondent to the RERA on a daily basis. Needless to say that complainants and the respondents are bound by the terms and conditions of the said allotment number 1 and 2, this authority has no jurisdiction to rewrite the terms of the said allotment as agreed by the parties pre-RERA period, and that the same which was once consented by the parties cannot now at a later stage seek recourse under the latter enactment. No order to the cost. Chairman Ajay Mehta. Now, in this case, in the allotment letter, the builder had written that if they fail to give the possession on time, so they will give 12% interest to the home buyers. Now, what happens? We got the order in our favor. Now, what happens? The builder files a complaint against all the 137 home buyers. The complaint itself is not maintainable. So builder has made all of them as a respondent, whereas the order is in our favor. Now, the interesting part is the day one itself, the chairman of the RERA should have not entered in this complaint, because there is no provision in RERA where the builder can file a complaint. And what is the prayer? I'll just show you the prayer. And it is so ridiculous. So we are thinking of going into the High Court. That first is how the RERA can entertain such type of complaint which is not maintainable. And what is the prayers? See, now this is the prayer. In view of the facts mentioned about the complainant applicant prays for the following relief. That this honorable authority be pleased to direct the respondent to pay the entire balance receivable as stated in Exhibit D, thereto in the manner stated in the letter of 1st August 2022, Exhibit G, into the account of so-and-so maintained by the complainant. So in the one go, he wants that all the 137 home buyers should pay him the money, right? And then he will construct. So how this complaint is maintainable? So on the hearing, I was there, my colleague was also there. So we told we want to file a written submission to counter this. So he's telling, no, it is reserved for order. And filing of this complaint, if you see the date, and within 30 days, it came for the hearing, because the builder has filed. When the home buyer files, it takes 1.5 years for the first hearing. Can you see this? This is the latest one, 18/11/2022. It came for the hearing, and on the first hearing, not adhering to the natural justice, principle of natural justice. If he has given in writing, we should also be allowed to put our written submission. Though I have made an RTI that I want a Rojnama of that, till date I have not got it. But it is reserved for order, but no order has been passed yet. The home buyer is supposed to receive the money when the builder is going to give the possession, because they have given that money since 2010, 2 crores, 1.5 crores, and hardly any amount is, supposed to be paid to the builder. So they are going to receive the possession of the flat plus the delay of interest. Now, what the builder has connivingly done is he has filed a complaint against all the 137 home buyers that you pay the money and in one shot, then only I will construct the balance work. So the RERA should not have entertained this complaint, and it should have been dismissed on the day one. But now it is reserved for order. So let's see what the order comes. Now I want to show you something. This is State Consumer Dispute Redressal Commission, Kalagoda, Neeraj Saxena and others. The common order, I'm not going into this order, but I'll go to the second order. See, this is the beauty, because the Consumer Act has come from 1986, and again it was amended in 2019, repealing the 1986 Act. So what were the flaws in that act have been taken care of. Now, whatever here highlighted here is, thereafter the matter was adjourned on 20/12/2021. Thereafter on 12/4/2022, matters were taken on board on that day also. Advocates for opponent number 1 and 2 were present. It was recorded on 12th April 2010 that as per record, matter is kept for submission of written version by opponents subject to limitation. So what is the subject to limitation in consumer court? The first is 30 days and it can be extended to another 15 days. That is total 45 days. It was taken on board on 4th May 2022. On that day, advocate for the opponents were present, and it was recorded that the written version is to be filed within the limitation. Matter was further listed 6 July 2022. On that day, advocate for the opponent sought time for filing reply to the application, filed the complainants. Thereafter, it was adjourned to 21 July 2022. On that day, the present application was moved along with written version. It can be said that the written version was tendered in this commission on 21 July 2022. According to the opponent's, written version was ready on 27th May 2022 as it was affirmed before the notary, but it was not produced on record due to the vacation. It was contended that the copy of written version was served upon the complainant on 4th June 2022. Even the said fact, the consideration as undisputed, that will not be helpful to the opponent. Section 13, subsection 1, subsection A of the Consumer Protection Act 1986 reads as the Section 13 of the Consumer Protection Act, procedure on the admission of the complaint. The district forum shall, on admission of a complaint, it relates to any goods, refer a copy of the admitted complaint within 21 days from the date of admission to the opposite parties mentioned in the complaint, directing him to give his version of the case within the period of 30 days or such extended period not exceeding 15 days, as may be granted by the district forum. So the complaints to proceed without written version against the opponent numbers 1 and 2 as per the Roznama dated 4th October 2022, matters are already proceeded without written version of the opponent number 3. So this is the beauty of the Consumer Code, because if you see, the presiding officer is who? Justice S.P. Tawade and S.B. Barne, judicial members. So they have a judicial background. Whereas in RERA, they are all IAS officers. Initially, there were judicial magistrate, retired magistrate or district judges were there, like Kapadnis or Kulkarni, Mahadev Kulkarni. But now they have all retired and they have been refilled by IAS officers. So they don't apply their judicial mind. I'm sorry, the act is such a good act, RERA, but the presiding officers and the way it has been implemented, it is not giving the result which is desired. Now, there is why this was there. We got the order in our favor, interim order, based on this judgment. So if you are going to file any complaint in Consumer Court, go for the Multi-Purpose Cold Storage Private Limited. This matter went up to the Supreme Court, and Supreme Court had that for nobody has the jurisdiction like District Forum, State Commission or NCDRC to extend any period beyond 45 days, and they have upheld the order of all the 3 trial court below it. So even the NCDRC gave the same order that they don't have the jurisdiction, which was challenged in Supreme Court, and Supreme Court also upheld the order that the maximum period 45 days is the time limit for filing your written submission, and it cannot be. The first question referred to whether the Section 13 subsection 2A of the Consumer Protection Act, which provides for the respondent opposite party filing the response of the complaint within 30 days or such extended period not exceeding 15 days, should be read as a mandatory or directory. That is, whether the district forum has power to extend the time limit for filing the response beyond the period of 15 days in addition to 30 days. The second question is, which is referred to us, that would be the commencing point of limitation of 30 days stipulated under the aforesaid section. The first question was referred by 2 judges bench. This court wide order dated 11/2/2016 passed in civil appeal number so and so. There is an apparent conflict between the decision of this court in top line shoes. Now, the crux of this judgment is that nobody has the jurisdiction to extend 30 plus 15 days, that is 45 days. So that is the beauty of going to the Consumer Court.
I have a question, like in redevelopment project also, it involves marketing, advertising, selling or allotment of apartment. Then why RERA is not applicable on them, as you said?
No. You see, RERA, I'll tell you. For the sale component, RERA is applicable, not for the rehab component. And if the sale component is more than 8 units, then only they have to go for the registration. Now, this is a fight which we have to come up together, that even the rehab component, the existing member should be treated with because they are also parting with their property, with their assets. But in consumer court, you can, if it is delayed, even if you are an existing member, you can approach the consumer court.
Sir, I have another question. Like allottee as defined in section 2D, allottee means in real estate projects means a person to whom plot or apartment or building has been allotted, sold or otherwise transferred. So can you elaborate this otherwise transferred?
See, otherwise transferred can be in such a way that I have a land. So in bargain, instead of giving me cash, he's giving me certain flats, 2 flats, 3 flats, or 4 flats. So that will come in the otherwise.
So I have one concept of EOI. Now the builders come up with the concept of EOI, that is intimation or kind of an interest.
Expression of interest.
Yes, sir. So I wanted to know how under RERA it has been. I feel that it has not been covered under
I'll tell you.
same.
I'll tell you one thing. The RERA has given you the tool that
Yes, sir.
there has to be an allotment letter.
Yes, sir.
Can builder force you or compel you that no, this I will give you as an EOI? You are giving the money. So you stick to it that I want an allotment letter which will specify the consideration value, which will specify the carpet area as per RERA, and which will specify the date of possession. Then only I'm going to give you the money. Otherwise, why I should give the money? See, you are the king. Consumer is the king. You should not bow down to the builder's demand. He will come to you if he wants to sell the flat. That is simple. If doing any malpractice, we can bring it to the RERA. You can write this thing that this is not as per RERA. As per RERA, you give me an allotment letter, and see that allotment letter and the draft agreement, they are uploaded on the RERA website. If builder is violating that, you can always complain to the builder.
Okay, so that's where the thing is. EOI is not in the format of a booking, and hence then the stand.
But why you should go when I'm booking the flat, so I'll seek for an allotment letter.
Correct.
Seek for an allotment letter. Otherwise, don't part your money.
Correct. And otherwise, the particular person stands as an investor and not as a purchaser, as they claim so.
Yeah. In RERA, they will then twist it, and it will become an investor. But if you approach the consumer court, you are still treated as a consumer. And there is question 1 in the chat, section 18. So that's why, sir, I told you that I prefer consumer court more than the RERA. My first 100% practice was in RERA, but now I have diverted my clients to the consumer court. So 50% of RERA and 50% of the consumer court. So consumer court is anytime better than the RERA. But RERA has given you many things. First is that the date of possession he has to mention on the website of the RERA. Then the area he has to mention what area he is going to give you. So there are many clarities. The title is there, the draft agreement is there, then allotment letter is there. If he is giving you something else like EOI, you can complain to RERA. Nobody can force you that you have to sign on the EOI. Say no. As per RERA, the allotment letter has to be in this format, and then only I'm going to part with the money, and then only I'm going to sign, and you also sign. The question is the possession delay suit. Can allottee file interest and compensation at RERA and consumer forum simultaneously? No, my dear. You have to file either in RERA or in consumer court. Is that the updation of every project after completion is compulsory, required, or not? If yes, then what is the reason behind? See, as per RERA, every quarterly he has to update what is the progress of the project, how much money he has received, how much units he has sold. And after the completion, he has to update that this project is over and that there is no harm for this thing. See, the same, now I don't know, I have not met any such builder who has given the possession when the last installment is still pending. I have not yet found one. And if the builder is very good and very big-hearted and generous, and he has given the possession and the last payment due, which is from the home buyer, is not been received by the builder, he can always file a complaint in the RERA. And I have not come across any builder who gives you the possession without taking the full money. In fact, they take more money than what is required. I hope this answers your question.
सर आपने अभी थोड़ी देर पहले बताया था रेरा का 8 फ्लोर तक, मतलब अगर 7th फ्लोर बनाएंगे तो 8वीं फ्लोर पे जाएंगे तो उनको रजिस्ट्रेशन करना पड़ता है.
No,
Below-
don't go by the floors. It is
Oh.
unit. If it is anything which is more than 8 units, he has to register. Or if it is more than 500 square meter plot, he has to register with RERA. It is
Okay,
the number
okay.
of units.
सो सर कहाँ पे कितने यूनिट्स बनाने के बाद मैंडेटरी रजिस्टर करना
The
मैंडेटरी है?
moment in his plan he has more than 8 units, he has to go for the registration of the flat.
I wanted to ask, like in my agreement, the possession date is mentioned like 31st December 2021. And it also states like there is a 1-year grace period.
Okay.
But on RERA, it says like, it's 31st December 2022. Now I'm pretty much confused, like, which is the actual possession date where, I can.
What is specified in the agreement and which agreement is registered will comply.
Okay, so RERA date doesn't matter over here.
No, RERA, see, he has entered into an agreement with you, no?
Yes, correct.
That by 21st December 2021, he will give you the possession. And whatever he uploads on the RERA website is something different. Maybe he wants extension of time, but what is written in the agreement will hold good.
Okay, and what about that statement which state like, the builder has 1 year of grace period as well?
He can extend 1 year, but that doesn't mean that whatever the right you have as an allottee are going to be compromised. Your right as an allottee are intact, no matter he keeps on extending the date.
I want to clarify one aspect with regard to the every quarter the builder has to upload the quarterly progress report.
Updates, quarterly updates. The progress of the project as well as what amount he has received and what work he has undertaken.
So during this COVID period, the physical mode of updating of this quarterly progress report was not available with the builder. So, what had happened, like on the website of the RERA, the total number of units sold was only like 340. And on the basis of the information available on the RERA website, we filed a case in the NCLT. So the number of that home buyers required was only 10%. That means 38 or means less than 40. So we filed as per that we were 38 applicants and we filed it. Later on, he gave us the excuse during the hearing that because of the this COVID situation, he could not update. However, there was a notification from the RERA that the online update, that updation of the information was available to the builders. So can he take this as a defense?
No, that see, physically I understand, but everybody was working online. That he has to do online. He doesn't have to visit anyone.
So he cannot take the defense.
No, he cannot. He cannot take that.